let's go on the record in the case of the state of Wisconsin.
That's Elijah, sir.
Thank you. Appreciate that. Versus Elijah Larrue, and I'm unfortunately missing the case number right now. Maybe Mr. Clerk can call the rest of the case.
That's 20 CF 885.
Okay, thank you. It's just not fully booked into the computer system yet because of the timing of the filing of the complaint. That's no big problem. May we have the appearances, please?
William Brown for the state of Wisconsin.
Good afternoon. This is Attorney Mike Khari appearing via home for Mr. Larrue.
Okay, thank you. And Mr. Larrue, I can see you via video. I hope that you can hear us. Can you?
Yes, sir.
Okay, thank you. And at some point during the course of this, you decide that you want to have a confidential communication with Mr. Covey, please let us know that, and we can make arrangements for that to occur. It would have to be relatively brief, but we could at least make it happen. Is there a specific branch assignment that we should be employing here, Mr. Brown?
The judge or commissioner, the co-defendant, Mr. Sanford, has a pending DPU case in branch 11, so I believe that would take precedence and assign the case there.
I think that's correct. By local court rule, we'll assign the case to Judge Burrs. That does not prejudice anyone's ability to seek substitution if otherwise available. What is the state's position regarding bail in Mr. Larrue's case?
The state requests bail of $1 million cash. Obviously, the defendant's charged with the most serious crime in Wisconsin. If convicted, he is facing a mandatory sentence of life in prison. The only question will be parole. I will say that it is believed that Mr. Larrue was recruited or brought along by Mr. Sanford to participate in this crime, which was likely a burglary that's turned into a kidnapping and then a homicide. I'll note Mr. Larrue's cell phone was turned over to police and tracked via GPS coordinates that phone transmitted throughout the evening. The evening of the homicide, which is alleged to have occurred around 11:05 p.m. At the Arboretum in the University of Wisconsin campus, Mr. Larrue's cell phone plots himself driving around the victim's neighborhood for several hours, then following that, moving to the Arboretum and being in that location around the time shots were reported being fired by neighbors of the Arboretum. Following that, Mr. Larrue's cell phone tracks back to an Airbnb apartments where Mr. Sanford, along with the victim's daughter, were residing. So it is believed that Mr. Larrue was an integral part of this homicide. He was there, and he participated.
Sorry, you're kind of fading out a little bit, Mr. Brown.
Sure, he was there and he participated. I believe $1 million.
I'm sorry, could you go back just a little bit, 2 sentences back, please?
I think the problem might be technological. If the parties that aren't speaking can mute their microphones, the public defender's office and maybe the bailiff at the jail, if they can mute the microphone while the defendant isn't talking. Thank you.
As I was saying, it's believed that the defendant was an integral part of the homicide. He was there. He accompanied Mr. Sanford the entire evening, including that information. Witness statements from numerous people, as you detailed in the criminal complaint, put Mr. Larrue with Mr. Sanford the evening of the homicide. And so I believe $1 million is absolutely appropriate. As conditions of bail, I ask that he not possess any dangerous weapon, he have no contact with the co-defendant, Mr. Sanford, and that he have no contact with the victim's family at all.
Commissioner, you're on mute. Is it my turn to speak?
I couldn't hear.
That was operator error on my part. I apologize. Go ahead, Mr. Covey.
Thank you. Judge, for the record, I just received a copy of the complaint approximately 20 minutes ago. I believe my client, Mr. Larrue, was handed a paper copy of the complaint a few moments ago. We waived reading of the complaint. The address seems to be correct, though I understand that he will be at the Dane County Jail time being. There is no doubt that what's alleged here is absolutely serious. It's of the gravest type of crime. But I still think $1 million is inappropriate in this case. I met with my client this morning. It's my understanding that he has no history of any kind of juvenile adjudication. He certainly has no adult criminal history. He just turned 18 years old. His ties to the community are significant. I believe he's lived in this community for most, if not all, of his life. He has family here. It is my understanding, and again, I don't have the benefit of having the police reports, that when the arrest was made a few days ago, that Mr. Larrue was cooperative with the arrest. There was no indication that he was trying to flee. I recognize that he's going to be placed on a high cash bond. I recognize that this court is well aware of the presumption of innocence, and also that perhaps anything I say right now is almost a moot point, because whether or not you set the cash bond at $5,000, $50,000, or $500,000, it's unlikely that Elijah is going to be able to bond himself out. That being said, I think $1 million is excessive considering the mitigating factors I just talked about. I think it's, I guess I would be asking for a significantly lower cash bond. I don't have an exact number to give you, but certainly well below $1 million on this. Thank you.
Okay, thank you. I have had an opportunity to look at the criminal complaint. I think it is supported by probable cause. I understand that the allegation is that Mr. Larrue's liability is more party to the crime liability rather than direct actor liability. That said, under Wisconsin law, that still qualifies him for the same possible maximum penalties. The maximum penalties for one count of first-degree intentional homicide is the possibility of life imprisonment without the possibility of parole. That's not always the result, of course, but that's the maximum that's available. Mr. Larrue is charged with being party to 2 homicides. There's a lot we don't know about this case yet, and that's true. And there's also a lot of process ahead of us. This is the very beginning of it. Part of that process is the fact that at some point the state's going to have to, or can be at least held to the burden of having to prove its case beyond a reasonable doubt. And the fact that that's a burden, and it's a heavy one, does weigh into the bail decision that gets made. I also, though, I'm supposed to set cash bail at an amount that's deemed necessary to assure appearance in court. That's a very difficult thing to do when the possibility is life imprisonment. And you know, there are bail systems out there in the world, including in the country, and there's even a movement afoot, I think, to try to change some of our bail systems to be more consistent with this, where for an offense of this sort, there just likely wouldn't be a cash bail set. There would be the binary choice of whether to release somebody on an unsecured bond of sorts, or to just have them held without the possibility of bail. Wisconsin law requires that a bail be set because the preventative detention law has not been invoked by anyone. So I do have to put a number on it. That said, I just can't really quarrel with the state's request in this case. It's an incredible amount of money. There's no doubt about that. It's an incredible amount of money for anyone, and Mr. Covey represents that. It's maybe particularly so for Mr. Larrue. But I don't know what the amount of money is that would be that would work in a case like this to assure appearance in court without something along the lines of what the state's been asking for or is asking for. So I am going to adopt the state's request. I'm going to set cash bail at $1 million. I'm going to adopt the requested conditions because I believe they are reasonable. I think we should get the matter scheduled for a preliminary hearing next week. That's an opportunity for bail to be reviewed, of course, as well. Mr. Clerk, do you have a court date for us?
Yes, the prelim will be April 16th at 9 a.m. in branch 4, trial branch 11.
I'm sorry, April 16th at 9 o'clock?
Yes, in branch 4.
Thank you.
Okay, thank you.